We are here today to discuss to you about the practice of law. So the case that was assigned to us is ULEP versus the legal clinic with BM number 553 dated June 17, 1983. And with this case, we will be able to know what constitutes practice of law, and we will also know if lawyers are allowed to advertise their services to the public. But before we begin our discussion, let us first introduce ourselves. I am Mustafa Simeon Ampatuan, and I will be your facilitator for this discussion.
I am Carly May Sanquina.
Everyone, I am Leia Manon-og.
Hello, my name is Grego Centillas.
I'm Nathaniel Millado.
Hello, I am Princess Betty Cabanog.
I am Maria Ani Yanong.
I am Jolie Lim.
I am Alan Francis Polinar.
Okay, so thank you for that introduction. So let us begin with our discussion. Ma'am Carle and Sir Nathaniel, can you tell us what happened on this case?
Preview of the case, facts. In particular, as called from the records of the case, the following are the advertisement of the legal clinic. Annex A, secret marriage, 560 pesos for a valid marriage. Info on divorce, absence, annulment, visa. Please call 521-0767 legal, 521-7232, 52-22041. Clinic is open from 8:30 to 6 p.m. at 7th floor Victoria Building, UNW, Metro Manila. Annex B, Guam Divorce, Don Parkinson. An attorney in Guam is giving free books on Guam divorce through the legal clinic beginning Monday to Friday during office hours. Guam divorce, annulment of marriage, immigration problems, visa extension, quota, non-quota residence, and special retirees visa. Declaration of absence, remarriage to Filipina fiancés, adoption, investment in the Philippines, U.S. foreign visa for Filipina spouse and their children. 7F Victoria Building, 429 UN Avenue, Legal Ermita, Manila, number U.S. Embassy Clinic Incorporated. Telephone number 521-7232, 521-522-2041, 521-0767. Petitioner Mario C. Olip, aware that those advertisements are champertus, unethical, demeaning of the law profession, and destructive of the confidence of the community and the integrity of the members of the bar, and that as a member of the legal profession, he is ashamed and offended by the said advertisement. Respondent asserts that the legal clinic is not engaged in the practice of law, but engaged in giving legal support services to lawyers and laymen through experienced paralegals with the use of modern computers and electronic machines. Respondent further argues that assuming that the services advertised are legal services, the act of advertising these services should be allowed supposedly in the light of the case of John R. Bates and Van Osten versus State Bar of Arizona, reportedly decided by the United States Supreme Court on June 7, 1977. Those are the facts of the case.
To continue, petitioner praised this court to order the respondent, the Legal Clinic Incorporated, to cease and desist from issuing advertisements similar to or of the same tenor as that of Annexes A and B of said petition, and to perpetually prohibit persons or entities from making advertisements pertaining to the exercise of the law profession other than those allowed by law. Position papers. The implication of the controversy is of great importance. The Supreme Court required the following: Integrated Bar of the Philippines, Philippine Bar Association, Philippine Lawyers Association, UP Women's Lawyers Circle, Women Lawyers Association of the Philippines, Federation International de Abogados, or FIDA, to submit their position papers and render memoranda. The said bar associations readily responded and extended their valuable services and cooperation, of which this court takes note with appreciation and gratitude.
For the issue number 1 of this case, may I call on Sir Lagnayo?
Issue number 1. Whether or not the services offered by the legal clinic constitutes the practice of law.
Okay, to answer the issue number 1, I would call on Mr. Centillas and Mr. Polinar.
In this case, the Supreme Court ruled the practice of law means any activity in or out of court which requires the application of the law, legal procedures, knowledge, training, and experience. Generally, to practice law is to give advice or render any kind of service that involves legal knowledge or skill. 1. Legal advice and instructions to clients to inform them of their rights and obligations. 2. Preparation for clients of documents requiring knowledge of legal principles not possessed by an ordinary layman. 3. Appearance for clients before the public tribunals which possess power and authority to determine rights of life, liberty, and property according to law, in order to assist in proper interpretation and enforcement of law.
In addition, the Supreme Court in the case of Land Title Abstract and Trust Corporation versus Dworkin also provides that the practice of law is not limited to the conduct of cases in court. A person is also considered to be in the practice of law when he, for valuable consideration, engages in the business of advising persons, firms, associations, or corporations as to their rights under the law, or appears in a representative capacity as an advocate in the proceedings, whether pending or prospective legal proceedings before any court, or appears in a representative capacity as a commissioner, referee, board, body, committee, or commission constituted by law or authorized to settle controversies in such capacity performs any acts or acts for the purpose of obtaining or defending the rights of their clients under the law. Otherwise stated, one who, in a representative capacity, engages in the business of advising clients as to their rights under the law, or while so engaged performs any act or acts either in court or outside of court for that purpose, is engaged in the practice of law.
So for the issue number 2, I would like to call on Ma'am Cabanog.
As to the second issue, whether or not their services can properly be the subject of advertisement. It is worthy to note that the respondent here argued that the act of advertising should be allowed in the line with the ruling of Bates versus State Bar of Arizona, which was decided by the United States Supreme Court. Also, there are 5 position papers and memoranda submitted on the issues involved in this bar matter.
For the ruling number 2, I would like to call on Ma'am Yanong and Ma'am Manon-og.
Thank you, sir. So, although on this ruling, it is allowed that some persons not duly licensed to practice law are or have been permitted with a limited representation in behalf of another or to render legal services, but such allowable services are limited in scope and extent by the law, rules, or regulations granting permission therefore. If the person involved is both lawyer and non-lawyer, the Code of Professional Responsibility provides in Rule 1508 that a lawyer who is engaged in another profession or occupation concurrently with the practice of law, shall make clear to his client whether he is acting as a lawyer or in another capacity.
Likewise, Canon 3 of the Code of Professional Responsibility provides that a lawyer, in making known his legal services, shall use only true, honest, fair, dignified, and objective information or statement of facts. Canon 3.01 adds that he is not supposed to use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualifications or legal services. Nor shall he pay or give something of value to representative of the mass media in anticipation of or in return for publicity to attract legal business. The canons of professional ethics before the adoption of the Code of Professional Responsibility had also warned that lawyers should not resort to indirect advertisements for professional employment, such as furnishing or inspiring newspaper comments or procuring his photograph to be published in connection with causes in which the lawyer have been engaged of concerning the manner of the conduct, the magnitude of the interest involved, the importance of the lawyer's position, and all other like self-laudation. So applying the criteria, the activities of the legal practice of law with its attorneys and so-called paralegals, it will necessarily have to explain to the client the intricacies of the law and advise him or her on the proper course of action to be taken as may be provided for by the said law. That is, what its advertisement represents and for which services it will consequently charge and be paid. That activity falls clearly within the definition of the practice of law.
So to discuss the dispositive portion of our discussion, I would like to call on Mr. Lim.
For the dispositive portion of this resolution, the court resolves to restrain and enjoin the legal clinic incorporated, the hearing respondent, from issuing or causing the publication of dissemination of any advertisement in any form which is similar or of the same tenor and purpose as that indicates in the annexes A and B of the petition, and from conducting directly or indirectly any activity, operations, or transactions prescribed by the law or the Code of Professional Ethics. Attorney Rogelio P. Nogales, who is a member of the Philippine Bar, being the major stockholder and the proprietor of the Legal Clinic Incorporated, and that being the prime incorporator thereof, is reprimanded with a warning that any repetition of the same or similar acts involved in this proceeding will be dealt with more severely. As to the questions regarding the legality or illegality of the purpose for which the Legal Clinic Incorporated was created, the court was constrained to refrain from resolving the said aspect as it is clearly not within the adjudicative parameters of the present proceedings, which is merely administrative in nature. The court further ruled that it is imperative that the matter be promptly determined. However, the same must be made in different proceedings and forum. It further stated that the remedy for the apparent breach of prohibition made by the respondent is the concern and the province of the Solicitor General, who can institute a quo warranto action after duly ascertaining as to the factual background and basis for the grant of respondent's corporate charter. The court further resolves that the copies of the resolution be furnished and the Integrated Bar of the Philippines, the Office of the Bar Confidant, and the Office of the Solicitor General for their appropriate action.
That ends our discussion. I hope that you enjoyed listening, and please don't forget to like, share this video, and comment below for further discussion. Again, thank you for listening, and may we all have a wonderful holiday ahead of us.